As we have referred Antigone's play, we are going to discuss today Natural Law School of Jurisprudence, wherein we'll be discussing Natural Law School of Jurisprudence as well as the theory of natural rights. Dear friends, it has been said that ubi societas ibi jus. That means wherever there is a society, there is a law. इसका मतलब जहां जहां समाज है वहां कानून का अस्तित्व होता ही है. अब नेचुरल लॉ का जो स्कूल ऑफ ज्यूरिस्प्रूडेंस है, व्हाट डज इट ट्राइज टू कन्वे टू अस? इट सेज nature is an orderly thing. Man is a part of that nature. And by this nature, man is endowed with an ability of active reasoning, which helps us, which inspires us. This ability of active reasoning helps the man in having sense of गुड और इविल. जैसे कि इंसान और नेचर का जो रिश्ता है, इसके बारे में कुछ टिप्पणी नेचुरल लॉ स्कूल ऑफ ज्यूरिस्प्रूडेंस करता है. जैसे नेचर एक ऑर्डरली थिंग है, ये सिस्टमैटिक है. इंसान उस नेचर का एक महत्वपूर्ण अंग है और इस इंसान को बाय नेचर एक शक्ति मिली है जिसे हम विवेक की शक्ति कहेंगे, रीजन की शक्ति कहेंगे. उस रीजन की शक्ति से प्रेरणा लेते हुए इंसान अच्छे और भले बुरे की पहचान कर सकता है. एंड दैट इज व्हाट द बेसिक आइडिया ऑफ नेचुरल लॉ. फ्रेंड्स, नेचुरल लॉ School of Jurisprudence can be categorized into 4 phases. First phase is often termed as classical or ancient period. Thereafter, the medieval period. Thereafter, the period of Renaissance and the modern period. So, what was the idea of the law that was at very center in Natural Law School of Jurisprudence? As per the classical or ancient kind of approach towards studying the law, the thinkers right from Socrates, Aristotle, Plato, and so on, what they have construed, what they have come with, they opine that law is dictation by human reason. So, classical or ancient school of jurisprudence, that is the natural law school of jurisprudence, has tried to explain the nature of law. And law for them was dictation by the human reason. Thereafter, the medieval period, we'll see wherein the Thomas Aquinas, he has tried to explain what is the nature of law. For the medieval period natural lawyers, law is dictation by divine will. So medieval period natural lawyers, they equated the reason and which is basically law with reason, and that is the product of divine will. So they have related the natural law with the scriptures, that is the religion. Thereafter, the period of Renaissance, we find that with the advancement of new knowledge and technology, the thinkers, natural law thinkers, they certainly made a distinction between divine will and natural law and the reason, the human reason. And certainly, after looking into this, we need to see the characteristics of natural law. Friends, as per the Natural Law School of Jurisprudence, law emanates from an absolute source. So absolute source, sometimes it is nature or the divine kind of will, divine power. So there are two important pillars of natural law, that are justice and morality or ethics. Natural law is having another characteristic, that is, it is basically considered as unwritten kind of law. It is not codified one. Basically, it is unwritten kind of law. And it is a kind of based upon a priori method without going for actual experiencing or testing the ideas. So they are, that is, it is self-evident kind of a law. So it certainly doesn't give primacy to to any kind of inquiry into the ideas. It considers natural law is self-evident. It doesn't need any kind of evidence. Friends, the natural law is also based upon certain values. And it is considered that natural law is common for all states without any kind of distinction. As we have referred in earlier kind of a point, that nature is an orderly thing, man is part and parcel of that nature, and man is endowed with an ability of active thinking. So that reasoning inspires him to choose between good and bad. He can understand the consequences of evil. So accordingly, his acts are designed. So whatever these principles are there, they are trying to talk about the presence of natural law for all kind of the whole mankind. Friends, the natural law school has also taught the principle that unjust laws are no laws at all. So it is also trying to say that if there are the laws which go contrary to the man-made laws, which go contrary to the natural laws, they would be declared as unjust, as Antigone perceived. It is the basic right, inalienable right of every individual to have a decent and respectful kind of a burial. And if the king ordered not to give decent kind of a burial that goes contrary to the natural law, therefore she defied the orders of the king. Friends, we see various kind of interpretations with regard to the reason, human reason, and the natural law. Though these things sometimes contradict, change, two things that never change in a natural law school. So that are two important principles that remain unchanged is, number one, universal order governing man, which professes the principle of equality. Universal order governing all men. So the principle of equality that is originated from this very principle. The second principle that remains unchanged is inalienable rights of an individual. So the man by birth inherits certain rights which are inalienable. They cannot be transferred to anybody. So these are the basic kind of principles that remain unchanged in a natural law. Friends, now look into the impact of natural law upon the US legal system, thereafter Indian legal system, as well as UK's or English legal system. Dear friends, one of natural lawyer, John Locke, has propounded or given importance to the very rights like life, liberty, and state. And accordingly, under US Constitution, we do find life, liberty, and property of an individual are basic fundamental rights. That means the second principle we can see over here, that is inalienable rights of an individual. In the case of Plessy versus Ferguson in the year of 1806, it was held that racial segregation in the school amongst the student was held valid. The whites and Afro-Americans, they were considered as separate but equal. So that was a kind of delicate kind of the interpretation of law. Thereafter, it was found in the light of natural law and natural rights theory that in the case of Brown versus Board of Education in the year of 1954, racial segregation among the students was violation of the principle of equality. So whatever was held in Plessy versus Ferguson, that was certainly denied, and the Brown versus Board of Education came forward with another dynamic interpretation of natural law, natural rights theory. In this case, by declaring the principle of equality would violate if the students are segregated on the basis of their race. Dear friends, we also see the influence of natural law, school of jurisprudence, natural law theory, as well as natural rights theory upon English legal system. In Somerset's case of 1772, Lord Mansfield considered slavery is an institution which is so odious to the natural law that the English courts should not continue the same. And accordingly, we do see two principles that were interpreted by the relevant cases by the English legal system, which are called as principles of natural justice, namely, no person shall be a judge in his own case, and no one shall be condemned unheard. So this is what the principle of natural justice, which is nothing but a product of natural law theory and the theory of natural rights. So whatever the things that were happening worldwide, so India didn't remain unaffected. So we also find there is influence of impact of natural law theory as well as natural rights theory upon Indian legal system. Our very part 3 of the Constitution speaks about fundamental rights that are nothing but the basic non-transferable rights, inalienable rights that have been recognized by natural law. Article 13 of the Constitution speaks about the concept of law. Rather, it defines the law, and it says that if the legislature makes any law contrary to the part 3, that is fundamental rights of the Constitution, that would be declared invalid. So here also we can find that our Indian legal system has also supported the very idea of natural law theory and natural rights theory. The Constitution of India also speaks the language of natural laws. It starts with the preamble, which refers we the people of India. So one of the natural law has spoken about the general will of the people, and the preamble to the Constitution, it shows what was the general will, what is the general will of Indians, and that is certainly reflected in the preamble to the Constitution. Dear friends, in the Maneka Gandhi's case, we can see that there was positive interpretation of natural law theory and the theory of natural rights, wherein Article 21, the text of Article 21 of the Constitution doesn't refer the words due process of law. It is only referring the words procedure established by law. But the court positively read natural law in this particular case under Article 21, and it came forward with the new idea, the procedure must always be due, which is to be followed in the law. Thereafter, the cases like Nargis Mirza, wherein the discrimination on the lines of sex, that was considered as contrary to the principle of equality, and certainly that case also speaks about the positiveness of the positive interpretation of natural law in Indian